Hey guys, sorry I'm late. I usually am, though, so you're probably used to that by now. I'm not at my desk, as you can see. If you're watching this on replay, you could probably skip the first couple minutes. I got to ramble for a minute. I'll tell a story about somebody that you guys probably also follow and watch here. Um, but other than that, you can just skip ahead to when you see the document on the screen if you want to just get to the stuff that you're actually here to see. I'll also be doing, like a much shorter version of this tomorrow morning, where I will be at my desk. And if you don't want to stick around for however long I'm rambling about this, you can always wait for that. So um, while I'm here on the screen, I should tell you that I'm not going to be able to keep it on. I just got off my work day and I look at the computer for like 8+ hours. And so I have to wear these glasses now or I get like really bad headaches. And as you can see, when I put them on and I'm not at my desk, I'm on my laptop, it's all weird looking. So I'm going to turn my face off at some point while I'm reading this stuff. So this thing that came out, this 47.1 thing that just came out, everybody knew that was coming. It doesn't make it any less frustrating for me. And I think it sucks, but one of the things that stood out was this declaration that came with it. It's a redacted declaration. We don't know who is saying this stuff, but we'll go over it first. But I was just talking to somebody, like I said, that you guys might also follow. Her name's, we call her Little Girl Attorney on TikTok mostly, or you can find her here. Hang on, let me show you the tab real quick. But this is a friend of mine that I just met when I was out seeing Donna a couple weeks ago in Los Angeles. So if you don't follow her here, you should. She's really smart, and we were just talking, and I asked her a question, and she said she thought this sounded more like somebody from like Sony or WME than anything else. This declaration that we're going to go over first. So keep that in mind. When I met her a couple weeks ago, I was at Donna's and I was just absolutely toasted at the end of the night. And so she had to drive me back to my hotel and listen to my brain vomit for what felt like an hour. I don't know how long we were actually sitting there talking, but I swear to God, I was just talking more than I've talked to anyone in my entire life. So she's a great person. You should go check her out if you haven't yet. Hopefully we'll be seeing each other again soon. I'll be in California next month, but for the rest of this month, I'm just sticking around at home. Anyways, let me pull this up real quick. Like I said, I'm going to turn my screen off because it's just easier for me when I don't have to have the bright light in my face right after work. I have to take breaks, but this just came up and I wanted to get to it right away. So let me pull up the document. Okay. And then I promise you'll see my face again tomorrow or later tonight at 9:15 if you want to come back. I will have Omar on shortly, sometime this week. I have to find out when he's actually free, but he said yes to that. So I'll have him explain some of this stuff to you too, because when it comes to the 47.1 stuff, I'm not a lawyer. So, I'm not going to be able to, decipher some of that shit, but give me 1 second here. All right. Let me just get a sip of water real quick. I got it right here. Somebody says, love LGA. She seems so kind and so intelligent. She is both of those things, man. She's awesome. All right. So this declaration, like I said, is redacted. And this is the account of someone who is claiming that Justin was, well, why don't I just read it for you? Okay. Hopefully my mic is okay too. All right. I am over 18 years of age, of sound mind, and otherwise competent to make this declaration. The evidence set out in the foregoing declaration is based on my personal knowledge. Here's a bunch of redacted shit. Wayfarer Studios, LLC, something Justin Baldoni, a founder of Wayfarer, redacted. I had repeated negative interactions with Mr. Baldoni and his associates, including verbal abuse by Mr. Baldoni. Redacted. Mr. Baldoni, okay, I don't know what this says. I requested or something. Mr. Baldoni not be permitted on set during the majority of production as a result of those experiences. So here's what I think when I see this, including verbal abuse by Mr. Baldoni. First of all, I don't know for sure that this isn't like Blake's, right? I don't know if that's even possible, but otherwise it sounds like this could be some like WME soy boy or something. Like, I don't fucking know. Maybe somebody from Sony. And honestly, they just want to follow the money. So they're going to go with Ryan Reynolds' wife. So I don't really give a shit. But I had repeated negative interactions with Mr. Baldoni, including verbal abuse by Mr. Baldoni. Justin Baldoni, you know what? I don't care how many people think that I am an asshole for saying this. He did not do what these people are claiming that he's doing. All right. And I know people are out there will say that I am like a piece of shit for defending him, but I absolutely do not care. There's no way this man did this. He's not a verbally abusive person. He was playing an abuser in the film, getting into character. Maybe he snapped at somebody for a split second or something after that when he was in a heavy emotional scene where he was playing a very abusive person and actors have to get really into their character. I don't know. That's the only thing I could possibly think of. This man did not verbally abuse anyone. I don't give a fuck. Somebody's saying Isabella or Jenny. Isabella can eat shit for all I care. All right. I read that, stupid thing that her lawyer wrote about how the subpoena was harassment. And as somebody who had their location data, bank account, personal information, phone numbers, backup email addresses, and all that bullshit subpoenaed by Blake Lively because I said stuff about her that she doesn't like, Isabella can eat a bag of dicks. So I don't trust anything that she says. You know what? People on Reddit, let's go with this. They have called me verbally abusive because I called Blake Lively a bitch. You cannot verbally abuse someone that you have never met. And that's ridiculous. So people will claim verbal abuse over the dumbest shit, and it means absolutely nothing, especially because most of this is redacted. Everything meaningful here is redacted. So I don't care how much shit I'm going to get for saying that I don't believe a word in this thing. This is more of Ezra Hudson's mind games for all I care, So I don't believe it. I don't believe it. Show me some proof. All right. I requested that he not be involved in redacted, and there's a bunch of redacted stuff here too, marketing or public relations efforts, more redacted shit. I was contacted by the assistant to Steve Sarwitz, the co-founder and co-chairman of Wayfair, to schedule a time for me and Mr. Sarwitz to speak. Mr. Sarwitz's assistant did not identify a topic for the meeting, and then everything there is redacted. A true and correct copy of redacted, produced in Discovery as BL blah blah blah, is being submitted with this declaration as Exhibit 1. I declare under penalty of perjury that the foregoing is true and correct. That could be her fucking sister for all I know. And of course, we can't see that. So, look, I don't believe anything that these people say. I've been very, thorough, and I've explained to death why I don't believe everything they're saying, including the fact that they kind of implied that I was involved in some kind of scheme, and they used redacted or sealed information to do that. And then when they had their bluff called and that stuff got unsealed, they had egg on their face. They looked stupid as hell. And I think that's what's going to happen again. As soon as people find out what is actually behind this, redactions and all that stuff, they're going to look stupid again. No, I don't believe for a second that this man verbally abused anyone. I don't believe that he sexually harassed anyone. And I'm really sick and tired of these people's bullshit. I think this is a last-ditch effort to make him look terrible. I think a couple months ago, I sat there and I thought, you know what? I bet this is going to get a lot worse for him before it gets better, because I see how these people play their games. And I've been honest, I see both sides playing the PR game a lot, but this is actually such bullshit. I've not seen anything this outright dishonest with the Wayfair side than I have with Blake's side. So they might do things sometimes that the judge could say, look, this was, meant to get a public reaction or meant to incite scandal. But what they're saying, it isn't, outright untrue. These people will say things that are outright untrue and get away with it because of their clever wording. So, all right. And then, of course, there was also, I'm just going to roll over this real quick. It doesn't really tell us anything, but a declaration by Ezra Hudson, which you can trust something written by Ezra Hudson, about as much as you can trust her to answer one of my emails. So I respectfully submit this declaration in support of Ms. Lively's motion for attorney's fees, treble damages, which is like 3 times damages, and punitive damages against defendants Wayfarer Studios, Justin, Jamie, Steve, blah, blah, blah. I also submit this declaration to place before the court true and correct copies of the following documents. A true and correct copy of Signal chat messages dated February 1st, 2025, produced by non-party the Skyline Agency, LLC, bearing the bait stamped Skyline, blah, 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 is attached here too as Exhibit A. Look, these messages with the Skyline Agency who produced the website for Wayfarer Studios, like, the website includes 2 publicly available court documents. This is absolutely fucking dumb. 2 publicly available court documents, and you're like, I bet there's like some secret messages in the Signal chat that's totally going to make our case because we've got fucking nothing. No. Bullshit. There's nothing there for you to find. Again, it's like this weird cryptic shit that they rely on to kind of get the story going in their direction and to make Justin look like an asshole. And it's not working. All right. Give me 1 second. I get some more water. The thing is, if they hadn't showed their hand months ago, if they hadn't pulled the shit that they did with the content creator subpoenas and like all the redacted and sealed stuff that they had, promised would give information or reveal things that weren't actually there, then maybe I would actually be a little worried right now. But I'm not. Because I've seen how they play their game, and I know this is just more of that. So, exactly. Somebody says this reminds me of the tag BS all over again. It was massive nothing burger. Yep. Okay. All right. I will try to rein in my language, guys. I know I'm kind of all over the place right now. Hold up. So this is the actual memorandum in support of the... She moved for punitive damages, treble damages, and attorney's fees under 47.1. Now, 47.1 is meant to protect actual victims of sexual harassment. So, Lauren, if Blake Lively or Ryan Reynolds walk past you on the street, what would you say? Me, I would tell them they're crazy and keep walking. Nothing, dude. Nothing. I don't actually want anything to do with these people. I don't know why she wants my information, but I sure as fuck don't want hers. I would say nothing to her. I don't have anything rude to say to her. I have nothing to say to her at all. I don't want anything to do with her. What's up, Bruce? All right. The Wayfarer Party's defamation action against Blake Lively was baseless from the start. Okay, I see we're not getting any better here. Despite repeated warnings about the impropriety of their legal claims and the consequences of continuing to pursue them, the Wayfarer parties refused to back down. Instead, they stoked the flames of public sentiment, posting their retaliatory lawsuit on a public website alongside dozens of heavily redacted and context-free exhibits masquerading as receipts. Is this a fucking joke? To flood the zone with vicious character attacks on Miss Lively, designed to damage her credibility and to conceal their own unlawful acts. Holy shit! The projection is amazing. You of all people should know that you can't just, sue people over what's in a legal document. Surely you know that by now. I mean, it's worked in your favor, so. 1 second. Sounds like it can be Liz Plank. Liz Plank wasn't in the film, to my knowledge. She wouldn't have been on the set or had any power to ask that he not be on the set, and definitely had nothing to do with marketing. So it doesn't make sense for it to be Liz Plank. But fuck Liz Plank, by the way, because she's not a great person anyways. Liz Plank decided to make her point about men sexually harassing women by randomly sexually harassing men on the street and filming it. So Liz Plank can also eat a bag of dicks. All right. Instead, they stoked the flames of public sentiment, posting their retaliatory lawsuit on the website, blah, blah, blah. Okay. Alongside dozens of heavily redacted court context-free exhibits. Indeed, the Wayfarer parties tried their best to sue Miss Lively into oblivion and made substantial progress towards fulfilling Steve Sarowitz's threat to spend $100 million to ruin the lives of Miss Lively and her husband, leaving 2 dead bodies in his wake. Okay, there is absolutely no evidence whatsoever that that man ever said he wanted to leave dead bodies in his wake. I feel like their claim against Steve Sarowitz has evolved over time and it's gotten dumber. Somebody says if this was Robin, it would not look good for her case. Man, it might be. Who knows? Could be her for all I know, like I said. So, all right. This court has already recognized the Wayfair party's pattern of using filings on the docket as an opportunity to litigate this case in the press rather than in court, and to exploit the litigation process to invite public speculation and scandal. So what I talked about with Omar recently, in the last month or so, was how both sides do this, but only one side is running and crying to the judge every single time. Guess which side that is? Using a $400 million lawsuit against Miss Lively as their vehicle, the Wayfair parties tried to manufacture an air of legitimacy to their conduct. Sorry, I'm trying not to hiccup right now. A tactic about which this court has warned them and has cautioned the public and the press. Huh? What are you talking about? And while Miss Lively has used every tool available for her to try and stop this abuse, including moving to strike offensive filings, moving for sanctions under Rule 11 and Rule 3.6, and successfully moving to dismiss the Wayfair party's lawsuit in its entirety, their improper conduct continues unabated. Now Miss Lively seeks the deterrent remedy provided in California Civil Code Section 47.1, which prohibits the precise tactics that the Wayfair parties have deployed here, imposing severe penalties for unsuccessfully filing retaliatory defamation actions against sexual harassment and retaliation complainants. That's great. You actually do have to prove that there was some sexual harassment, yes? Because right now it's pretty apparent that you're just making it up. And it does suck because they do stuff like this and the mainstream media eats it up. And you saw it in the way that they covered like the YouTubers and even the one subscriber YouTuber, the way that they cover that, most of the media covers that, the bigger outlets cover that. It's all pandering to WME and their clients. It's frustrating. So they'll cover this the same way. They'll treat it like it's a fact, and then they'll kind of leave the other people as an afterthought or a footnote. They might ask for a quote from his attorneys or something at the 11th hour, and they might update it to include that later after everyone's already read it. It's a bunch of fucking bullshit. All right. Sorry, let me get a sip real quick. Somebody says, what receipts do they have that Sarowitz said he would spend $100 million? Good question, Roxanne. I don't doubt that he said that, but I sincerely believe that he said that in the context of, I will spend however much money I have to defend us against these false claims. So, there's absolutely no evidence to the contrary. There's no evidence that they said that he said what they're saying that he said. There's no evidence that he said what I'm saying he said. We don't fucking know. But the thing is, like, that is not, nobody made a threat to their life, a credible threat to their life, the way that they're trying to play it off now, that anyone actually reported or has any evidence of. So I don't believe it. Lively said she has a source who is willing to confirm that, but never confirmed it. Yeah. Uh-huh. All right. Under Section 47.1, any communication made by an individual without malice is important there, regarding an incident of sexual assault, again, also an important element that we're missing, harassment or discrimination, including retaliation, is privileged so long as the speaker has or at any time had a reasonable basis, again, important element here, to file a complaint of sexual assault, harassment, or discrimination, whether the complaint is or was filed or not. Section 47.1 ensures that individuals who experience sexual harassment or retaliation are able to share their experiences with courts, agencies, the press, and others without fear of being sued for doing so, and fuck you for exploiting that. The California legislature enacted this privilege to provide a clear, unambiguous pathway to justice for victims of sexual assault, harassment, and discrimination. Hey, so everybody should probably remember that when people came out with these amicus briefs, these California organizations or national organizations came out with these amicus briefs about the 47.1 thing here, at least one of those had Ezra Hudson involved with the organization in some official capacity. Just want to make sure nobody forgets that. And that she also exploited that when their lawsuit was dismissed, which had nothing to do with 47.1. The judge explicitly said he did not read the amicus briefs. And she used that in her post after it was, dismissed and said, the retaliatory lawsuit got dismissed. I stood up bravely with all these organizations to protect, people from retaliation and blah, 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 when that was not ever said in the ruling. Ever. It was explicitly, the opposite was explicitly said in the ruling. So this 47.1 thing really pisses me off. All right. Somebody says she was on the board. That's right. Yep. Okay. Specifically, Section 47.1 is intended to deter frivolous claims that force survivors to defend against a long and expensive retaliatory defamation lawsuit by imposing significant remedies for successful defendants in defamation claims. So none of that applies to Blake. Moreover, because Section 47.1 is intended to protect victims from the litigation itself, again, doesn't apply to Blake, these remedies must be available at the earliest stage, typically through a motion to dismiss to protect survivors from a punishing, protracted legal process. Consistent with Section 47.1's stated purpose, the court should act promptly to remedy the substantial harm Ms. Lively has incurred. And I think that if at this point, when no sexual harassment has been proven and has been, alleged shoddily, such bullshit, nobody should be able to get triple damages for that. Hey, what's up, Omen? How's it going? Yes, I'm the comedian. I've claimed I chimed in when I saw free speech was being violated by this case, specifically one-sided. Thanks, man. Thanks for stopping in, by the way. Okay. There can be no doubt that the Wayfair Party's suit is the prototypical suit that the California legislature intended to short-circuit by enacting 47.1. There can be no doubt of that. Lady, you lied. It's on tape. The alleged defamatory statements that form the basis of the Wayfair Party's lawsuit meet all the elements of privileged statements under that section for reasons this court has already recognized. Thus, as the prevailing defendant, Ms. Lively is entitled to her attorney's fees and costs, treble damages, and punitive damages. Nobody dismissed their lawsuit because it was frivolous. Ms. Lively is entitled to her attorney's fees and costs, treble damages, and punitive damages. As for punitive damages, the record as it currently exists is sufficient for the court to determine the Wayfair parties engaged in oppression, fraud, or malice. Oh my God. This lady's looking in the mirror, I swear to God. By bringing and maintaining their claims against Ms. Lively, entitling her to punitive damages under Civil Code Sections 47.1 and 3294. As set forth in greater detail below, oh God, we don't need more detail. The Wayfair parties and their lawyers used the now dismissed claims to peddle falsehoods in the media, and they did not stop even after the court granted Ms. Lively's motion to dismiss, misrepresenting in a televised interview the nature of the court's order. Whoa. You want to talk about misrepresenting the nature of the court's order while you're out here doing this bullshit? And feeding the media an online frenzy by thanking the internet sleuth community who continue to cover the case. It is hard to imagine a more straightforward application of Section 47.1. If that's true, then that law is fucking pathetic, including its provision for punitive damages. Accordingly, Ms. Lively respectfully requests a ruling that she is a prevailing defendant under Section 47.1, fuck you, and such that she is entitled to 1, her reasonable attorney's fees and costs, 2, treble damages for the harm caused by the Wayfair party's retaliatory defamation action against her, and 3, punitive damages sufficient to deter the Wayfair parties from engaging in such conduct in the future. God, I hate this lady. I'm sorry. I keep saying I don't, because I don't. This is not somebody who's in my life. She shouldn't have so much influence that I hate her. But I'm like, God, I hate this lady at this point. Because she actually did intrude on my life and my privacy. So I feel like I'm allowed to hate her. Following those legal determinations, Ms. Lively respectfully requests that the court set a schedule for the submission of affidavits and a decision after an evidentiary hearing, if necessary, as to the quantification of those awards, pursuant to Rule 54D1C. Some water, 1 second. All right. Facts and procedural history. A lot of this is probably I'm going to skim over probably a lot of this because we've seen it all before, and it's all still bullshit. Bullshit is still bullshit here. The Wayfarer parties openly discussed their intent to retaliate against Miss Lively. The Wayfarer parties have repeatedly made clear their intent to retaliate against Miss Lively, including by weaponizing the legal system. Okay, well, you're going to have to quote them on that one, please. As Miss Lively alleged in the SAC, that plan was backed by virtually unlimited resources. Wayfarer's co-founder, co-chairman, and leading financier is multi-billionaire Steve Sarowitz, who divulged to a witness at the film's New York premiere on August 6th that he was prepared to spend $100 million to ruin the lives of Miss Lively and her family. That was not the only time Mr. Sarowitz made such a threat. Oh, cute, okay. Later in August 2024, even though the film had turned out very well, and Wayfarer had made a lot of money on it, Mr. Sarowitz confessed to another witness, an individual who was working with Wayfarer on an unrelated project, that if Miss Lively or Mr. Reynolds ever cross the line ever, then I will go after them. Okay, well, this line right here, even if he said that, that's completely fair. They crossed the line so many times. He declared, I will protect the studio like Israel protected itself from Hamas. There were 39,000 dead bodies. There will be 2 dead bodies when I'm done, minimum. Not dead, but you're dead to me, so that kind of dead. Yeah, bro. But, okay, but dead to a lot of people. If they ever get me to that point, then I'll make it worth their while because I'm going to spend a lot of money to make sure that the studio is protected. Okay. So Declaration Exhibit 1, paragraphs 5 to 6. Wait, so what? Hold on. Whose declaration was that? Give me 1 second. In unsealed portions, nope, that's not it. This person also had concerns with Mr. Baldoni, who they found to be verbally abusive. So this declaration belongs to that person who made that claim, which resulted in him not being allowed on the set of the other project or involved in its marketing or publicity. Dude, so it wasn't even It Ends With Us. So this is somebody who has a grudge against Justin. This declaration is somebody who has a grudge against Justin from an unrelated project, and they're trying to pass it off as he abused somebody on the set of It Ends With Us? Holy shit. You guys are idiots. I thought that was somebody from It Ends With Us. You're actually full of fucking shit. This is intentionally misleading in such a way. You know not everybody's going to go through and read these footnotes. You know the press who covers this, they're not going to go through and read these footnotes. They're just going to see it's redacted. They're going to say some unknown person, also from the set of the film, said Justin was verbally abusive. But no, it was somebody on a separate project who has some kind of grudge against him who has now been brought into this. What a fucking cunt. Wow. This is such a disgrace to anybody who actually needs the protections that people fought so hard for survivors of sexual assault, abuse, harassment in the film industry. A fucking disgrace. And that's all she has, dude. That's all she has to back this stupid sexual harassment claim up, is somebody who hates him from a different project said some bullshit and then trying to pass that off like it's somehow related. Wow. They actually had me for a second, like, man, who could that be, you know? Wow. Wow. Okay. No, that totally tracks. That's totally on brand for them. At the end of the day, saying that they are dead to him, no matter what colorful language or descriptions he used, you're dead to me, when he explicitly says not dead, not physically dead, that is not a crime. That is not harassment. He was venting to someone else that he knows on an unrelated project. And he's saying he's going to spend a lot of money to make sure the studio is protected. Fucking moron Blake is. All right, 1 sec. Wow. That's so crazy, man. All right. Sorry, I was looking at my phone. All right. I'm going to have to text some people after this. Thus, let's see. Thus, the court need look no further than the Wayfair party's own statements to confirm their intent to retaliate against Miss Lively for reporting sexual harassment. I think we already went through this part. If not, it's a dead horse that's been beaten. So, I mean, whatever. But dead to a lot of people. I'm sorry. I can't get back to that. All right. Yeah, sexual harassment and retaliation, including by filing their now dismissed claims. The Wayfair parties begin seeding their false litigation narrative the day after Miss Lively files her CRD complaint and then file frivolous claims. All right, lady. It says this could all be a setup for a final twist in court come March 2026 when Pacino, like in And Justice for All, Ezra Hudson shouts, and Blake Lively should go straight to fucking jail. All right, man. Miss Lively filed her verified administrative complaint before the California Civil Rights Department. Shut up. Trying to make that sound way more legit than it is. Nobody verified that the claims were true. Okay? The very next day, in the wee hours of the morning, after the Wayfair parties had been served cease and desist letters along with a copy of the CRD complaint, Mr. Friedman, in his capacity as counsel for the Wayfair parties, the horror, provided an inflammatory statement to TMZ. The statement accused Miss Lively of lying in the CRD complaint, calling it shameful. I 100% agree, and I think that's just a fact. And declaring her allegations completely false, outrageous, and intentionally salacious with an intent to publicly hurt, as part of yet another attempt to fix her negative reputation that he claimed she brought on herself. She did bring it on herself. She went to the New York Times before she filed the CRD. This was all a publicity stunt because she couldn't handle the criticism and accept that her actions led to organic backlash. Okay, let's read this real quick. In unsealed portions of her deposition transcript filed with the court, Ms. Lively testified that she not only felt that the lawsuit and Mr. Friedman's conduct was retaliatory. Okay, she felt that the lawsuit and Mr. Friedman's conduct was retaliatory. Okay, well, let me finish this first. But that Mr. Sarowitz's dead body's threat on the heels of his pledge to spend $100 million to ruin her life left her concerned for her physical safety and, as a mother, for that of her family. Nobody has threatened your family, and he clearly said, even in your made-up, make-believe version of events, that he didn't mean physically dead. So, she felt that it was retaliatory. She felt that she was threatened. About as much as I feel threatened by her asking for my bank account. How about that? Take that and go fuck yourself with it. I don't care. All right. This person also had concerns with Mr. Baldoni. That's the one we read. Justin Baldoni's lawyer, Brian Friedman, says he's going to sue Blake Lively. And we're talking about the Megyn Kelly thing again. Megyn Kelly, who we now know was subpoenaed and was not very happy about it. Okay. But she didn't say anything about it until the last couple of weeks, which was kind of interesting. So, yeah. Well, we know all about this already, so I'm going to skim over this. Wayfair parties filed a retaliatory defamation lawsuit directly in this court. You saying that doesn't make it true. Also roping in her husband, Ryan Reynolds, and Leslie Sloan, her publicist. Leslie Sloan is also a cunt, so no sympathy from me. On January 31st, barely 2 weeks after filing their initial complaint in this court, and 11 weeks before the deadline to file a motion to amend, the Wayfair parties filed a 391-page first amended complaint, including a 168-page narrative Exhibit A, asserting 9 causes of action against Ms. Lively and the other defendants, this time adding in the New York Times as a defendant. Each Wayfair party asserted 7 causes of action against Ms. Lively, including 4, 1, civil extortion, 2, intentional interference with contractual relations, and we know all this stuff, so I'm not going to fucking read all that. Okay. The Wayfair defendants also brought a claim for false light invasion of privacy, with one exception, the false light claim. Each cause of action was asserted by all of the Wayfair parties against Ms. Lively. This lawsuit was accompanied by the creation of a website entitled thelawsuitinfo.com. She is very fucking salty about public documents making their way to the public. I mean, gosh. The entitlement, thinking they should be able to access it through a website instead of paying for it individually through Pacer. Which is not fucking cheap, by the way. I can attest to that. And I did in my declaration. which I had to file because she tried to bring me into her lawsuit. All right. 1 second, get some water. All right. Let's see. I don't think we need to read this. A lot of this is redacted, too. Indeed, in a contemporaneous Signal group chat in February 2025, and of course it's redacted, which means absolutely fucking nothing, because Ezra Hudson attested to this, which means whatever they're insinuating is probably a lie. Later that day, after the website launched, the group... What did they do, Ezra? I mean, okay. The group published public court documents on the website. Go fuck yourself. As this court already found, the First Amendment complaint was rooted in 2 buckets of allegedly injurious statements by Ms. Lively. A, that the Wayfarer parties engaged in, permitted, and or failed to prevent sexually inappropriate conduct towards Lively. Okay, I don't think that was actually found to be true, necessarily. Like... Or false, hang on. So I don't think that was actually found to be... Okay, yes. So they didn't actually find that Ms. Lively's statements were true or the Wayfarer Party statements were false. Right? So stuff was protected by privilege. They had pleading deficiencies. A lot of stuff that I totally didn't agree with, but I'm also a layperson and not a lawyer, so who fucking knows. But I trust Omar's judgment, obviously, a lot. He's one of the smartest people that I know, so and he had a lot to say about that. If you guys didn't hear it, you can always go back and listen. So these statements underlay all the Wayfarer Party's claims. Blah, blah, blah. I don't need to relive this stuff. This right here, though, regarding the claims of interference with prospective economic advantage, because the Wayfarer Parties do not allege that Reynolds' statements were defamatory. They do not allege that they were independently wrongful. Fuck off. All right. Ms. Lively moves to dismiss the First Amendment complaint, and the Wayfarer parties repeatedly refuse to withdraw their deficient claims. Well, they obviously didn't agree that they weren't deficient. So, all right. On March 20th, 2025, Ms. Lively filed her successful motion to dismiss. I remember when that judgment came out, I was in Australia. It was sometime in the early hours of the morning there, and I had a flight later that day. So I went on with Omar. No, I think I went on myself and went over it, which I was a little confused by because I don't totally understand the law parts of it. Then I went on with Omar, which made more sense. And then I went with Omar on to Ask Two Lawyers briefly before I had to go to the airport. So that was a long-ass day for me because I had to go all the way back to California from Melbourne. God. I was exhausted. But I gotta say, even with the sleep deprivation and then reading it again afterwards, I still think it was kind of fucking dumb, but all right. Okay. Not entirely. Like, some of it made sense, right? Like, some of it is just like, it's the name of the game. Some stuff is privileged. I understand why it is privileged, and I understand why it needs to be there to protect some people in certain circumstances, especially with the media stuff. But at the same time, a lot of it, I was kind of like, okay, you're stretching things a little bit where you shouldn't be stretching them. So, all right. Thereafter, on April 23rd, Ms. Lively served Mr. Sarowitz, blah, 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 with letters under FRCP 11C. We all know about those, which were very frustrating also. Let's see. On May 19th, Ms. Lively filed a motion for sanctions under FRCP 11. In that motion, Ms. Lively set out in detail why all the Rule 11 plaintiffs' claims against her failed as a matter of law. In response to Ms. Lively's Rule 11 motion, the Rule 11 plaintiffs did not even attempt to stand behind their claims on the merits. Instead, they argued, in essence, that the court should ignore the requirements imposed. Okay, shut up. Should ignore the requirements imposed by Rule 11 that parties and counsel submit pleadings that are brought in good faith, and instead merely dismiss any deficient claims under FRCP 12b6. All right. D, the court grants Ms. Lively's motion to dismiss the First Amendment complaint. We all know how that went. I'm sure they'll reframe it a little bit, but we've discussed why that was dismissed. Okay. In dismissing the Wayfair party's defamation action against Miss Lively, the court concluded that her statements were privileged under the Fair Report and litigation privilege. That doesn't mean they're true or correct, by the way. The court did not rule on whether Miss Lively's alleged statements were privileged under Section 47.1. Wow! Some truth. Okay. Or whether Miss Lively acted with actual malice, but permitted Miss Lively to renew her motion for attorney's fees, treble damages, and punitive damages under Section 47.1. In granting the parallel motions to dismiss, the court did, however, rule that the Wayfair parties failed to plead actual malice on the part of Mr. Reynolds, Miss Sloan, and the New York Times, finding that the Wayfair parties failed to allege facts that would have caused the defendants to doubt Miss Lively's accounts. So that right there was kind of where I was like iffy about it. I was like, I don't think this makes sense, but like I said, I'm not a lawyer, so okay, we're going to skip over that. The court also found there to be sufficient evidence of a smear campaign to defeat the Wayfair party's defamation claim against the New York Times. No. Sorry, no. No. Nope. In concluding that the Wayfair parties failed to allege actual malice on the part of the New York Times, the court held the CRD complaint and article contained numerous messages and documents strongly suggesting the Wayfair parties did spread negative stories about Lively, and I think that's bullshit again. The judge was pushing it there. The Wayfair parties' statements regarding sending negative content to Digital and Wallace's attempt to shine a spotlight on Blake and Ryan are inexplicable unless the Wayfair parties were spreading negative content about Lively, and that is absolutely fucking insane for the judge to come to that conclusion. I'm sorry. And this, I don't know why I'm apologizing. You guys obviously think the same thing, but I try to be very fair in that front. I try not to cry, or like, not cry, but like, I try not to claim bias unless I feel very strongly about something. And so I kind of like, I err on the side of caution heavily with this kind of stuff. But that is one of those things where I'm kind of like, man, I feel like you're doing a little too much, and it concerns me a little bit. All right. It is fair to presume that the Wayfair parties did what they said they had planned to do. Those messages are what is contained in the article and referenced in the video. This was without discovery, by the way, so this is totally out of context. A reader of those messages would have little doubt that the Wayfair parties engaged in a smear campaign, and that concerns me that the judge doesn't understand PR. But okay. All right. I'm not going to read any more of this because we already know this stuff from the judgment. That does not, in my opinion, totally mean there was a smear campaign. I don't think the judge definitively said there was a smear campaign. I think that he said the New York Times, not Blake, but the New York Times had reason to, not even reason to believe, but no reason to doubt that there was a smear campaign. So it just doesn't they're just like, they have every reason to, I guess, go with what's published in the complaints or provided to them from the complaint and not, question that without any sort of real evidence to the contrary that would make them think like, hey, I don't know if this is actually true. This doesn't make sense. So that's kind of where I felt like that was going. Wayfair parties and their counsel repeatedly attacked Miss Lively and her family in the media and abused the litigation process and this court's orders. So we've seen plenty about that lately. She's trying to get sanctions against Brian Friedman, and we read all those tables and lists of things that were said and blah, 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 and I just don't give a shit about it anymore. I know she's really mad about the Madison Square Garden thing. Personally, I think she should get the fuck over it. It's honestly not a thing to be such a diva about. It was clearly said in jest. So, okay. He then filed 2 letters and an affidavit with the court making allegations against Miss Lively and her counsel that were so improper, they were stricken from the record. What was that about again? Oops, I did not mean to do that. I clicked on the link by accident. What was that about again? Something about you extorting your former best friend who did not tell you about her engagement, and you're now trying to convince the press that you dumped her. I mean, what was that about? But no, it was not in his jurisdiction, so it made no sense for them to, I guess, file it there. I guess they could say, like, Lively's attorney has filed something about it there first, and so they were just responding. But at the same time, I did understand why that was, why the judge struck that. So, all right. Give me 1 second, I'm going to get some more water. Okay. You're still mad about Mr. Friedman thanking the internet sleuth community, pouring gasoline on the already blazing media frenzy, and encouraging the same type of online trolling that got the Wayfair party sued in the first place. All right, bitch. You can't tell me that you were never getting online trolls before this, but now all of a sudden, when you realize it might be your fault, you're blaming it on someone else and freaking out about it. Like, okay. I mean, how long did Shasti sit on that interview for before she published it? Think about it. This was all her actions. They just came to light all together at once because she was acting in a way that people didn't like. And then, of course, she was getting a lot of backlash, didn't know how to handle it. And she's like, you know what? I guess I should sue these people. Okay. All right. Yeah, I'm not going to read that part. It's just more of the same. Ms. Lively's allegedly defamatory statements are privileged under Section 47.1, which mandates a fees and damages award. So she's saying it's privileged. It protects Ms. Lively's statements about sexual harassment and retaliation by the Wayfair parties, and in fact was created to deter the filing of exactly this kind of complaint. Again, I think this is bullshit, but a communication is privileged under Section 47.1 when it is 1, regarding an incident of sexual assault, harassment, or discrimination. Well, we don't pass the sniff test there if it's made up. 2, made without actual malice. And 3, made by an individual that has or at any time had a reasonable basis, to file a complaint of sexual assault, harassment, or discrimination. Again, we're failing on all 3 points here, dude. This isn't a flex. All right. California enacted Section 47.1 to clarify and codify existing law in direct response to repeated attacks upon individuals who report sexual harassment and to provide a strong remedy to disincentivize retaliatory litigation, curb a pervasive culture of sexual assault and harassment, and provide significant remedies for successful defendants in defamation claims. And again, fuck you for exploiting that. Members of the California legislature explained that Section 47.1 was necessary because the Me Too movement had unveiled a predatory culture that persists across all sectors of employment and society, in which many victims have been served with defamation lawsuits. And again, fuck you for exploiting that. I don't really know what else to say about it, to be honest. All right, I'm going to skip over that. Ms. Lively's allegedly defamatory statements are communications protected by Section 47.1. I don't think we need to really do this. We all know this story. In fact, the Wayfair parties conceded as much in their opposition to Ms. Lively's motion to dismiss. They confirmed that their claims arose from statements that Ms. Lively made in legal filings about Mr. Baldoni and Mr. Heath's sexually harassing behavior. But those things were defamatory because they're not true. So, or they should be at least. Ms. Lively's allegedly defamatory statements were without malice. Well, that's just a lie. So, I'm not going to fuck with that. Here, the FAC is replete with admissions confirming the truth of Ms. Lively's allegations. Are you fucking stupid? Just tell me you don't know how to read. Okay. At best, the FAC asserts that Ms. Lively published the alleged statements either to save her own reputation or as part of a power grab. That's not something you want to brag about, is it? They allege she needed a scapegoat for her missteps in promoting the film. They claim she was driven by overweening ambition and a need for control. 3, they assert she wanted to match her star husband or boost her own brand and business ventures. And 4, they state she was determined to extract creative control and steal the film, or take over the production of the sequel, It Starts With Us. But, as described above, none of these theories contain allegations that Ms. Lively fabricated the sexual harassment allegations. Okay. Fabricated the sexual harassment allegations or insinuations and the protections for return to production, particularly given that so many of those insinuations directly tracked actual incidents that the FAC concedes occurred. No. 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 That's a bunch of bullshit. Moreover, the FAC offers no plausible basis to infer that Ms. Lively would, over a period of years, 1, knowingly fabricate sexual harassment claims. 2, repeatedly report her concerns to her superiors, including Baldoni, Heath, Wayfair, and Sony. Right, okay. 3, negotiate contractual protections to address her concerns. Those weren't to address her concerns. That was an absolute, way to take control of things. 4, file complaints with state and federal government agencies. And finally, 5, initiate this litigation, further exposing herself to the precise public backlash the Wayfarer parties promised to unleash. No, that never happened. They never promised to unleash anything. All to have the kind of creative control she presumably could have obtained by simply being one of the most powerful stars in the world. Don't flatter yourself, sweetheart. I mean, it's true. She's a very powerful person because her husband is extremely famous and more profitable than she'll ever be. And I hate to say that because I feel like sometimes it does feel a little bit like icky to say that because it's like, oh, your worth is based on a man, but the man in question is Ryan Reynolds, who is, like I said, much more rich, powerful, and profitable than she is, and that's just the truth. That's a fact. Nobody can argue the contrary, you know what I mean? So, all right. The court's order on Ms. Lively's motion to dismiss lends further support to the inescapable conclusion that Ms. Lively's statements were made without actual malice. No. Ms. Lively had a reasonable basis to file her complaints. No, again. Finally, to be protected by Section 47.1, the speaker need only have, or at any time had, a reasonable basis to file a complaint of sexual assault, harassment, or discrimination, whether the complaint is or was filed or not. In other words, the privilege attaches regardless of whether a complaint is ever filed, and no matter to whom the communication is published. Neat. You weren't sexually harassed. It is self-evident that Ms. Lively had more than a reasonable basis to report her workplace concerns during production and to file her complaints, both with the CRD and this court, and the FAC provides, I think, no plausible basis to conclude otherwise. Again, I disagree. Ms. Lively is therefore a prevailing defendant under Section 47.1, and God help us all if that's true. And as such, she is entitled to her attorney's fees and costs, treble damages, and punitive damages. All right. The court should award Ms. Lively damages under Section 47.1. Ms. Lively is entitled to her attorney's fees and costs and defending against the Wayfarer party's claims. I feel like this is more of the same. I don't really want to fuck with this. Ms. Lively is entitled to damages for harm caused by the defamation action. Ms. Lively is entitled to treble damages for harm suffered. Fuck you. Ms. Lively is also entitled to compensation for all harm caused to her by the Wayfarer party's retaliatory defamation action, including her economic, emotional, and psychological harms. Hey, remember when you had to withdraw your emotional distress claims? Prove it. Ms. Lively is entitled to punitive damages. Okay. Unlike other claims that apply punitive damages based on the underlying allegations of wrongdoing, under Section 47.1, such damages are based on bringing the lawsuit itself. Thus, the conduct to be assessed in imposing punitive damages here is the Wayfarer party's actions in bringing and maintaining their claims against Ms. Lively, conduct that was and continues to be unquestionably oppressive, fraudulent, and malicious. Unquestionably. I have a lot of questions. Okay, well, I'm not going to entertain that. California state courts and New York federal courts applying California law consistently award punitive damages against parties who maintain baseless litigation positions, including through their attorneys. Okay. Not doing the case law stuff. I'll wait for Omar on that. Moreover, it is proper to award punitive damages against a litigant for their attorney's conduct. Wonder who she'd be talking about there. When the litigant continues to retain the attorney despite knowledge of their malicious, fraudulent, or oppressive conduct. I am looking at you, Isabella Ferrer. I mean, okay. But, okay. We'll go with that. Sure. Again, this is something I want to bring Omar in on. I don't want to get into it too much alone. As set forth above, the Wayfarer parties with and through their lead attorney, Mr. Friedman, brought and maintained claims that were not based on factual or legal merit. Again, nobody has ever found that to be the case. But instead a deliberate plan to discredit Ms. Lively and to harm her and her husband, by suing them into oblivion. Cool. Counsel for Ms. Lively has already presented to the court the extensive efforts by Mr. Friedman on behalf of the Wayfair parties to assail Miss Lively in the press, even after Miss Lively amended her complaint to add claims related to Mr. Friedman's defamatory statements, and as recently as just a few weeks ago, using tactics designed to make his clients appear to be the true victims. Prove that they're not. And again, they're going to try to use the Darvo thing here, which I think is overused, beat to death. It's basically, at this point, a TikTok term that anyone can apply in any situation if they bend and twist it enough. So I am not fucking with that. Also, I think it's a huge disservice for them to use Darvo in this context when their client is the one doing the Darvoing. So the court should set a schedule for promptly quantifying these monetary awards. The Wayfair party's case, which was independently filed and not a cross-complaint, has been dismissed, making Miss Lively a prevailing defendant for purposes of this motion and rendering her Section 47.1 claims ripe. As such, the court should set a schedule for promptly quantifying the monetary award to which Miss Lively is entitled well in advance of the March 2026 trial in her case. And that is fucked up, dude. That is fucked. Pursuant to Federal Rule of Civil Procedure 54D2C, in these circumstances, Rule 54D provides the appropriate procedure for deciding questions of liability for harms, including fees inflicted by the litigation itself. All right. Again, I want to bring Omar in on this part, so I'm not going to do too much here. To the extent the court deems an evidentiary hearing appropriate, it should be prior to and separate from the jury trial in Miss Lively's affirmative case. Conclusion, for the foregoing reasons, the court should grant Miss Lively's renewed motion for attorney's fees and costs, treble damages, and punitive damage under Section 47.1, and set schedule for determining any disputed factual issues relating to these damages awards pursuant to Rule 54D2C, including the measure of Miss Lively's harm. Including the measure of Miss Lively's harm and the amount of punitive damages that should be imposed against the Wayfair parties. All right. Well, that was a lot of bullshit. So, sorry, I'm just trying to, let me read through these real quick, guys. Tammy Hashiyama, thank you for the $2. Don't train in your language, Lauren. I mean, I certainly didn't. I meant to, but I didn't. Millennial Mom, thank you for the $5. People are saying it's Liz Plank. I don't think it makes sense for it to be Liz Plank. That's just me, though. But then again, that's when I thought it was, someone on set. So maybe it is Liz Plank, Maybe it is. Could be. Eliza Little, thank you for the $20 for a stiff drink or gummies. Thanks. Love you, Lauren. Thank you. Love you back. Jen Decker, thank you for the $5. No nonsense, Lauren. Tell him I'm doing my best for sure. All right. Thanks, guys. I have got to go take a little break from looking at the screen, go outside and shit, because I got to come back in a couple hours for a different case. So, and like I said, I'll do a shorter version of this tomorrow morning. So if you couldn't listen to all this rambling or you just got here, you're welcome to just wait for that. Somebody says Ryan must be, Cassidy, hey, what's up? Ryan must be sick of paying. That's certainly true, I think. All right. Thanks, guys. Appreciate it. Thanks for listening to my little rambling. Like I said, I'll be back later, so I'll see you all soon. Bye.